All right. So we are about to start our session today, but we are still waiting for some of our participants. As I can see, there are only few participants as of now.
Hello everyone. Good afternoon, Rohan.
Okay. Yes. Mahima, shall we begin?
Yeah, sure.
Okay. So let's start with our session, and this session is live on YouTube as well. So a very good afternoon, one and all. I am Anumat Nagar, webinar executive, and I welcome you all on this another session on Civil Procedure Code, trend analysis, judiciary examination with live practice. So again, we are here, and today we'll do analysis of those questions which has been frequently asked in the last judiciary examination. So I hope we have a routine audience, but those who are new to this session, let me just tell you what we are going to do in this session. So we'll be having a live mock on the questions. You will see certain amount of questions on your screen, and you have to answer the same. The format will be MCQ, and you have to answer in a chat box. And in the end of each and every question, we'll tell you the correct explanation along with how you need to approach that particular question. So also like there are certain rules and regulation which you need to follow while you will be answering to the questions. So and in the end we'll tell you the top three winners for the session. So I hope everybody is ready, and I will definitely appreciate if each one of you will participate. And also it's a free live mock, so avail this opportunity at large. Also we have a little surprise come a workshop details for you all. So we'll tell you a brief about that after 20 to 25 minutes of this session today. So today, as a quiz organizer, we have with us Mahima Khurana. She is a senior associate at 𝗏𝗏𝗃𝗏. So I welcome you, Mahima, and let's get started. But before that, I'll request you to tell our participants that how many questions we'll be having, along with the time allotment and the certain rules and regulations which they should abide. Over to you, Mahima.
Okay. Uh, Hello everyone. I hope everything is going good with you. कल बिहार एग्जाम हो गया. बिहार prelims was conducted yesterday. I think जिसने भी दिया है they outstood it, and obviously paper थोड़ा medium level का था. We'll talk about it later in one of our sessions now. Aaj we are back again with civil procedure code only. Deliberately we are back again with civil procedure code because as I've mentioned in my social media also that it has so much capabilities to make or break your exam, because civil procedure code has been analyzed as one of the pain points for every law student, not only judiciary aspirants but also every other law students जो जिसने भी सीपीसी का थोड़ा सा भी टच करा है, they feel slight like they feel slight roughness in that subject, as I also do, कि थोड़ा सा mugging up है, थोड़ा सा rote learning है. So that is why we are back again with the CPC mock. And yes, there are 30 questions, 10 seconds for each questions. Guys, I would want every one of you to participate as much as you can. अभी तक जो mocks हुआ, I can see 80% participants generally participate. But for today, and because CPC hai, I would want every one of you to participate. Live mock hai. This is a very good opportunity for every one of you guys, and also on YouTube and on Zoom. Please live chat box use karo, answers do. There's no negative marking. Make your concepts clear. Ask as many doubts as possible. I'm here to clear each and every question जो मैं आज यहाँ पूछ रही हूँ. So yeah, let's quickly begin with the session. And as Anu already have mentioned that at the end of this session we have a surprise for you, and that is the workshop. जो पहले से हैं they might have an idea about it already. जो नए हैं, for them एक अच्छी चीज पता चलने वाली है आज. And also let me just share my screen and start with the session. You have to write the question and then the answer, like the question number 1, and then mention the answer for it. Okay, ऐसे mark नहीं होगा answer, time limit के अंदर mark करना answer. जैसे ही मैं question as soon as I'll start reading the question, your time will start और उससे आपको 20 seconds मिलेंगे. Okay, so try to mention within the time frame. Okay, is my screen visible, Anu?
Yes, your screen is visible. Yes, and it is an announcement for both the Zoom attendees and the YouTube viewers if they are watching. तो आपको question number लिखना है, then your appropriate answers. ये format रहेगा पूरे live practice के duration में. Yes, Mahima.
Okay, ठीक है. So we are beginning with the quiz now. Get ready. Open your chat boxes और उसके बाद try to answer it. First question is, okay, my slide is not, sorry. Okay, the doctrine of res judicata as contained in section 11 is based on the maxim nemo debet 𝗵𝗃𝗃𝗃 pro una eadem causa intrust republicae ut sit finis litium lex non cogit ad impossibilia, both 1 and 2. Mention the correct question number and then the option. मुझे पता है आंसर्स पता चल गए हैं आधे लोगों को बिकॉज स्लाइड स्विच हो गई थी. So I'll give a less amount of time for you for this question. Okay, stop answering. So the correct answer is both 1 and 2. Option number D is correct answer. Option D is the correct answer. ठीक है. Okay. Nemo debet 𝗵𝗃𝗃𝗃𝗃 pro una eadem causa. That means nobody can be punished twice. Intrust republicae ut sit finis litium. It is in the interest of law that the litigation should end. These two maxims are obviously based on the principle of res judicata, but lex non cogit ad impossibilia is not based on this doctrine. Res judicata, it is not based on this doctrine. This is something else. So both 1 and 2 is the correct option. A and B are the correct option. Okay. ठीक है. So let me also tell you before moving on to the next question. Question की difficulty level vary करता रहेगा. So I don't want any one of you to leave just because of the fact कि आपको ऐसा लगे कि questions नहीं बन रहे. ठीक है. Okay. Second question is, no order for detention of the judgment debtor in civil prison in execution of a decree for the payment of money shall be made where the total amount rupees 500, 1000, 2000, 5000 does not exceed, where the total amount does not exceed 500, 1000, 2000, 5000. Last few seconds, guys. Okay, stop answering. Yeah, so the correct answer is option C. Option C is the correct answer. There's a section number 58, arrest and detention. वहां पे लिमिट्स दी हुई हैं फॉर इम्प्रिजनमेंट इन एग्जीक्यूशन ऑफ अ डिग्री, सिविल इम्प्रिजनमेंट, एंड देयर अ क्लॉज ऑल्सो जहां पे लिखा है फॉर रिमूवल ऑफ डाउट कि अगर 2000 से कम की डिग्री होगी देन देयर वुड बी नो पनिशमेंट, बट 2000 से ऊपर की डिग्रीज की लिमिट्स दी हुई हैं. फॉर 6 weeks there's some amount of punishment, for 3 months there's some amount of punishment, so that is there. Okay, तो ये था क्वेश्चन नंबर 2 एंड द करेक्ट ऑप्शन इज करेक्ट ऑप्शन इज ऑप्शन नंबर सी. Okay, question number 3 is, under CPC, if the court finds at any stage that it has no pecuniary jurisdiction with respect to the subject matter of the suit, it will dismiss the suit, proceed with the suit, amend the suit, return the suit. Come on, guys. Okay. Stop answering. Are we getting the answers, Anu?
Yes, we are getting answers both on YouTube and Zoom.
Great. Okay. So let me reveal the answer. The answer is option number D. Option D is the correct answer. Return the plaint. Order 7 rule 10 is the relevant order here. जब भी jurisdiction nahi hoti hai, so the suit will be returned, plaint will be returned, and the suit will also be returned. So that is the option number D here. Correct answer is option number D.
Still, those who are not answering with the question number, अपना question number mention करिए फिर option. A small announcement again. Thank you.
Question number 4 is, according to orders 20, rule 7 of Civil Procedure Code, the decree shall bear the date of the day on which the judgment was pronounced, the day on which the decree was made, the day on which plaint was filed, the day on which the day of the final judgment. Okay, stop answering. Yeah. So the correct answer is option A, the date on which the judgment was pronounced. Option number A is the correct answer. Okay. Yeah. So order 20 is judgment and decree, and rule 7 of order 20 deals with the date of decree. वहाँ पे पहली line में ही ये mention है कि the date on which the judgment was pronounced, the decree shall bear that date. तो डिक्री में जो डेट होगी वो जजमेंट की डेट होगी और किसी चीज की डेट नहीं होगी. दिस इज अ वेरी इंपॉर्टेंट क्वेश्चन एंड this has been asked in various prelims exams, various prelims of various state prelims exams. ठीक है, let's move forward now. Fifth question is, under CPC, which of the following is not a suit of civil nature? Suit for correcting the date of birth in the services record, suit for declaration of the right to worship, suit for vindication of a mere dignity connected with an office, suit for a religious office. Few last more seconds are left, guys. Okay. Stop answering. So the correct answer here is option C. Option C is the correct answer. All the other options are a suit of civil nature. Agar you will have an exhaustive reading of section 9, तो then you will come to know explanation 1 and explanation 2 के साथ कि ये तीनों चीजें in a way include हो जाती हैं civil suit के अंदर, civil suit के umbrella के अंदर. But option number C is obviously outcasted in that case. So option number C is the correct answer here. Okay. Okay. So question number 6 is, the court under section 89 clause 1 of the Code of Civil Procedure can refer the dispute for mediation or lok adalat, arbitration or conciliation, conciliation or mediation, all of the above. A very easy question. And the time is already running. Okay, stop answering. Yeah, so the correct answer is option D. Option D is the correct answer. All of the above. All of the above is the correct answer. Okay. 89 clause 1 में all these modes for resolution of a dispute are mentioned, but one mode is not included, and that is negotiation. So guys remember कि negotiation नहीं है. This is a very frequent question. ये तो easily framed question था. This is a very frequent question कि negotiation एक option में दे दिया होता है and then you would be required to fill that what modes are there, which all modes are there under 89 clause 1. So negotiation is not a mode under 89 clause 1. Okay. ठीक है. I guess we should move on towards the next question. Question number 7. Which one of the following is not required in filing representative suit in order 1, rule 8 of the Civil Procedure Code? Numerous parties, same interest, leave of the court, written permission of those who are being represented. Not required. Three more seconds. 2, 1. Stop answering. Okay. So the correct answer here is also option D. Option D is the correct answer. D. Okay. Option D is the correct answer. Okay. So why option D? Because बाकी सारी तीनों चीजें हैं. What is order 1 rule 8? It is a representative suit, obviously. Representative suit है that there's also a concept of representative suit in res judicata explanation 6. But for now, representative suit is order number 1 rule 8, where more than one party can together file a case on the behalf of everyone. So suppose I am representing a case on behalf of my whole on behalf of everyone who has the interest in the suit. So same interest should be there, numerous parties should be there, and obviously leave of the court should be there. But written permission of those who are being represented is not needed. I can be the person who can represent all of them without their written permission. So yeah, this is the concept and D is the correct answer. Question number 7 हो गया. ठीक है. We are moving towards question number 8. Guys, everyone, please try to participate and answer. Question number 8 is, an ex parte decree can be set aside on the ground that summons were not duly served, non-appearance of defendants as copies of documents filed with plaint were not provided to defendant, defendant refused to receive the summons and thereafter no fresh summons were issued to him. An ex parte decree cannot be set aside under any circumstances. Five more seconds are left. 3, 2. Stop answering. Okay, so the correct answer is option number 1. Option number A is correct. A is correct. Language में लिखा है. Option number A is the correct answer. Order 9 rule 13 is the relevant order here, relevant rule here, relevant provision here. Order 9 rule 13. Okay, तो order 9 rule 13 की language में लिखा है कि अब decree, an ex parte decree can be set aside only on the ground when the summons were not duly served or on any other ground through which the court is satisfied on any other sufficient cause. So there's no such thing mentioned as option number B and C. There's only one ground, and that is summons were not duly served. If summons were not duly served, then only the court can set aside your ex parte decree. And what is ex parte decree? An ex parte decree is when the defendant is absent and the plaintiff is present. Okay, so option number A is the correct answer. Okay. Question number 9 is, caveat shall not remain in force after expiry of 90 days, 60 days, 30 days, 15 days. बिहार पेपर में ये क्वेश्चन है, लास्ट मॉक में ये क्वेश्चन था. So realize the importance of this question. Okay, stop answering. So the correct answer is option number A. Option A is the correct answer. ठीक है, 90 days is the correct answer. ये the time limits in CPC is very important. रटना ही पड़ेगा चाहे कुछ हो जाए, because this was one of the questions in Bihar prelims also, and this was one of the questions in Chhattisgarh prelims also. वहाँ पे भी कुछ ऐसे questions थे. So 90 days is the limit. Caveat is a concept where you can obviously the person can file a caveat if he is in the apprehension that the application might get filed against him. So that is there, and for the period of 90 days that application will remain in force. 148A is the relevant provision here. You can read that provision. So yeah, question number 9 is that. Let's move towards the next question. Question 10. Any amount which a court will order to be paid as compensatory costs in respect of false or vexatious claims or defenses shall not exceed the amount of 2,000 rupees or the amount within its pecuniary jurisdiction, whichever is less, 3,000 rupees, 4,000 rupees, 5,000 rupees. Four more seconds are left. 3, 2, 1. And there you go. Yeah. Stop answering. So the correct answer is option number B. Option B is the correct answer. 35A is the relevant provision here. 35A is the relevant provision. So 35A में यही बात लिखी हुई है कि if a suit is filed on the ground of something false or vexatious, then the compensation would be 3,000 rupees. See, again a thing to be learned, to be बस रट्टा मारना है इस चीज का, है ना. तो 3,000 रुपए याद रखना है कि 35A में 3,000 रुपए है. देयर आर ऑल्सो सम अदर अमाउंट ऑफ पेनल्टीज जहां पे यू ऑल्सो हैव टू रिमेंबर दोज पेनल्टीज ऑल्सो. 25 सेक्शन 25 में एक पेनल्टी है. सो या ऑटोमेटिकली दिस फिगर्स जो न्यूमेरिकल फिगर्स हैं सीपीसी में वो अपने आप इंपॉर्टेंट है. So that was question number 10. Let's move quickly towards question number 11. 11 is, in execution of a decree for the maintenance, salary of a person cannot be attached to the extent of 1/4, 1/3, 2/3, 1/2. दो ऑप्शंस हैं जिसमें कंफ्यूजन होएगा ऑब्वियसली. Okay, stop answering. Yeah, so the correct answer is 1/3. Option B is the correct answer. B is the correct answer. Just B is the correct answer. Yeah, B. ठीक है. Section 60 में there is a catch. Section 60 में it is written opening line जो है Section 60 की उसमें लिखा है कि ये सारी चीजें attach नहीं हो सकती. तो salary in case of maintenance 1/3 salary cannot be attached, and in other cases first 1,000 and plus 2/3 of salary cannot be attached. So what can be attached in case of salary, in case of maintenance? How much salary in case of maintenance can be attached? 1 minus 1/3, that is 2/3. 2/3 salary can be attached, and what cannot be attached is 1/3. So guys, थोड़ा सा calculation करना पड़ता है इसके लिए. So remember that what cannot be attached is there under section 60. So 1/3 cannot be attached. This question could be made in a very complex manner. अगर ये पूछ लिया जाता कि salary of a person be attached, cannot की वजह से ये easy हो गया है. ठीक है. Okay. So next question is question number 12. Which one of the following questions may not be said to be a substantial question of law for the purpose of second appeal? A question of law in which there is conflict of judicial opinion, recording of finding without any evidence on record, taking into consideration irrelevant evidence, concurrent findings of fact recovered by court below. Not a substantial question. Last few seconds. Stop answering. Okay. Yeah. So the correct answer is option D. Option D is the correct answer. D. See, section 100 is the relevant section. Second appeal के लिए there should be a substantial question of law involved. But what is a substantial question of law? ये कहीं define नहीं है. So that is left on the discretion of a court, and the court has adopted very liberal approach towards it. So court has tried to include everything under the substantial question of law unless that is totally irrelevant. So concurrent finding of facts covered by courts, though courts ki concurrent findings, obviously when it already has been found out, so that is not considered as a substantial question of law. Other three cases are there under the substantial question of law. So yeah, that is the concept of second appeal and substantial question of law. Okay, so before moving for the next question, let us take a small break. Okay, we have 19 participants left. Guys, what are you doing? Please don't leave us.
Yes, questions is having both difficulty and simplicity. So I believe people are participating and that's good, and on YouTube as well. So just stay connected, participants.
Don't leave us. Try to answer each and every question. एक question difficult है, दूसरा तो easy होगा ही. But before moving on with our quiz, I would like to share something with you guys. That is the workshop, judiciary workshop organized by the 𝗀𝗃𝗃𝗃 course. Let me just share my screen first. Okay. I think my PC got hanged. Okay. Is my screen visible?
Yes, wait. Yes, now it is visible.
Okay. So the workshop name is create a step-by-step foolproof judiciary study plan for yourself and actually follow it. That is the most important thing, and actually follow it. Okay, because plan to koi bhi kar leta hai, but to follow it, it requires really something motivational and something very. Okay, so the enrollment is closing in 6 days, and the timing is 6 p.m. to 9 p.m. on 14 December. Remember the date, guys. Note the date, and the fees is just 200 rupees. This is the main feature here to be noted. 200 rupees may you are getting a 3-hour workshop, and where you will be guided about your preparation. Where are you standing? What do you need to kickstart your preparation? And if you have already been there preparing there, and then also you are not able to crack the exam, or you are not feeling confident, so there are these different stages of a student जहाँ पे उनको लगता है ऐसा कि they might lose hope. So what you guys need to stick to your preparation. That is what we are going to cover in this workshop. That is the main idea, and the agendas of this workshop is basically given here. So these many agendas are there. When should one start preparing for the interview stage? Which stage should you attempt for the exam for? How toppers make their preparation strategy? How to create mindset for judiciary preparation? Starting from very beginning to starting to the most important thing, how to divide your time daily, weekly, monthly, and everything, pros and cons of self-study. So everything will be covered in this workshop, and this workshop will be taken by Harsh Jain. Harsh sir is the co-founder of LawSikho, and he has himself cleared UGC NET JRF, Rajasthan exam, and many other government exams. Shweta Devgan, who is the project lead for test prep, and 𝗷𝗂𝗃𝗃𝗃𝗃, who is the co-founder and CEO of LawSikho. So yeah, that is there about the workshop. If you want the payment link, or if you want something else, some other guidance from us, you can just write it in the chat box, or also you can message us any time later. So yeah, that was there about the workshop.
Yes. And participants, I'm sharing a link with you all along with a chat WhatsApp group where you can get connected and you will get updates regarding the 𝗏𝗏𝗃𝗀. Whatever updates we'll be providing you, so you can join through that link, WhatsApp link, and the link for this judiciary workshop I have shared that as well. And I'll definitely think that this is a different workshop, and those who are in a monotonous preparation, like a single preparation if they are doing, so definitely they'll get a something different in this workshop. So whosoever is interested, kindly enroll for the same, and in the end of the session we'll try to give you all your answers if you have any regarding the workshop. Yes, Mahima.
26 participants say we have 16 participants. Awesome. Okay. Chalo, let's stick to 16 at least. At the end of this webinar, I would want all the 16 participants to be there with me. Try to answer as many as questions as possible. We are moving forward with the 13th question now. Is my screen visible now?
Yes, Mahima, it is visible.
So the 13th question is, let me open my stopwatch first, then I'll move. Okay. 13th question is, which one of the following is a public officer within the meaning of section 2 clause 17 of the Code of Civil Procedure? A judge, a sarpanch of gram panchayat, a municipal councillor, an officer of a corporation.
Guys, we are on question number 13. Try to answer. We are back with a live mock quiz. So those who are present in the session, try to answer.
Wake up, everyone. Please answer karo. Question number 13 it is. Stop answering. The time is already over. We are past the time. So the correct answer here is option number A, a judge. A judge is the correct answer. Okay. A judge is the correct answer. Okay. So the section 2. Section 2 is a very important section itself, just because of the fact that definition clause है, हर module का definition clause is very important, and when it comes to CPC the case is same. Section 2 clause 17 का first, am I audible? I think Anu is stuck. Okay.
Yes, you are audible.
Yeah, thank you. So section 2 clause 17 का first option है, first sub clause है A, and that is every judge. Every judge is a public officer within the meaning of section 2 clause 17. So have a reading of that section. ये तो बहुत easy frame question था, कुछ minute details भी आ सकती हैं in your exam, so be prepared for it. Okay. Question number 14 is, where a court can reject a plaint, where the plaintiff fails to comply with rule 9, where suit is barred by law, where plaint is not in duplicate, all of these. Okay. Stop answering. The time is up. So the correct answer is option number D. All of these. Option number D is the correct answer. अब ये question frame थोड़ा अजीब सा था, because where a plaintiff fails to comply with rule 9 of which order? Of order 7. Obviously of order 7. Plaint is there under order 7. So a little common sense is required here. Order 7 rule 9 is कि 7 दिन के अंदर अंदर plaint file करना है. अगर नहीं करा, then the court will reject a plaint. Obviously where a suit is barred by law is a ground under order 7 rule 11, and where the plaint is not filed in duplicate, also it is a ground under the same rule. So all of these is the correct answer. Rejection of a plaint is a very important topic. हर बार mention करती हूँ मैं, both from the point of view of mains and prelims. So yeah. Okay. 15th question is, A is entrusted to amend his plaint. The defendant is against it. The court must allow it to amend or not. If no, then when? When it is necessary to know the real position of the case, when it is necessary to avoid the plundering of the case, when there is fundamental change in the nature of the case, when there is possibility of delay in the proceedings of the case. This is a question from MP Judiciary. A very good question indeed. Okay. Stop answering. So the correct answer is option number C. C is the correct answer. C. ऐसे questions को give an exhaustive reading and read twice. Read the question twice, you will get the answer. बहुत common sense था. अगर fundamental change हो जाएगा case के nature में, then only the court will not allow to amend the plaint. Otherwise, amendment of pleadings is there under order 6, rule 14 or rule 17, I guess, rule 17 or 16. Yeah. So there is a provision under order 6 for relating to amendment of pleadings. So plaint is one of the pleadings, and plaint is obviously can be amended at any stage of the case. But if it cannot be amended, तो सिर्फ ये reason हो सकता है कि जहां पे case ही change हो रहा है, तो there is a fundamental change, then the court will not allow you to amend your plaint. ठीक है? So that is the correct answer. Okay. So let's move to, are we getting the answers, Anu?
Yes, the frequency is bit less now. So participants, it's all up to you. We are posing question for all you all. तो थोड़ा सा frequency कम है, but still we are getting answers.
Okay. Question का difficulty level अब थोड़ा कम होने वाला है, तो then you'll be able to answer. ठीक है. Let's move towards the next question then. Question number 16. Question number 16 is decree for payment of money passed against a woman cannot be executed by proceeding against her legal representative if she dies, by attachment and sale of a property, by appointing a receiver. Just a second. There's a problem. By her arrest and detention in prison. Guys, I'm sorry, but ठीक है. अब इसमें तो frequency ज़्यादा दिखा दो. Okay, stop answering. So the correct answer is option number, you all know the correct answer already. Option number D is the correct answer. Yeah. So D is the correct answer. Section 56 is the relevant section here. Detention or arrest nahi ho sakta hai of a woman in any case under CPC for execution of a decree. So that is mentioned under section 56. Yeah. I'll try not to reveal the answers beforehand now. Let's move on towards the next question then. 17 question is, under order 32 rule 9, a next friend of a minor can be removed if he ceases to reside in India during the pendency of the suit, where his interest become adverse of that of the minor, where he does not do his duty for any of the above reason. Six more seconds. 7, 5, 4, 3, 2, 1. Yeah, stop answering. Okay, so the correct answer is option number D. D is the correct answer. D. Okay, for any of the above reasons. Order 32 rule 9 is about the removal of a next friend of a minor. कोई भी तीनों चीजें हो जाती हैं, तो obviously the court can remove the next friend of a minor. So this is the correct answer, option number D. Okay. Okay, let's quickly move towards the next question then. 18th question is, a decision in a suit may operate as res judicata against persons not expressly named as parties to the suit by virtue of explanation. 2, 4, 6 or 8 of section 11. Five more seconds are left. Okay, stop answering. Yeah, so the correct answer is option number D. Sorry, option number C is the correct answer. C is the correct answer. C. Explanation 6 to section 11. Explanation 6 is about the representative suit, जहाँ पे parties are not expressly mentioned, the persons are not expressly mentioned. वहाँ पे भी res judicata may apply. Okay. So explanation 6 to section 11 is the correct answer. Option number C. Okay. ठीक है. So 19th question is, which of the following is not correct regarding the powers of appellate court? Have power to determine a case finally, have power to remand the case, not have power to take additional evidence, have power to frame issue and then refer them for trial. Very easy question. Very easy, guys. Okay. 2 more seconds. Stop answering. Yes. So the correct answer is option number C. 3 is the correct answer. Option number C is the correct answer. C. C. Okay. Not have power to take additional evidence. Section 107 is the relevant section. सारी powers हैं और third जो option है वो ये है कि the court has the power to take additional evidence. Just because of the word not, this option is automatically becomes wrong. So C is the correct answer. Okay. 20th question is, just a second. Yeah. 20th question is, appointment of a receiver has been dealt with under order 44, under order 42, 40 or 45. Guys, come on. Very easy, I must
He has
say.
made, question very easy by telling the numbers also. So you can choose the correct option now.
Okay, stop answering. Yeah. So the correct answer is option number C. Order 40 is the correct answer. Order 40. ठीक है. तो एक लिस्ट बनाओ, अपने रूम में चिपकाओ सारे ऑर्डर्स की. सारे ऑर्डर्स की हेडिंग्स की एक लिस्ट बनाओ, अपने रूम में चिपकाओ टू रिमेंबर द हेडिंग्स ऑफ द ऑर्डर्स एटलीस्ट, क्योंकि वो हेडिंग्स तो याद होनी चाहिए एंड दे आर इन द रोमन फॉर्मेट. तो यही आएगा. यू हैव टू लर्न द रोमन फॉर्मेट. This is 44, XL 14, 44, 42, 40, XL 5 is 45. So XL is 40, order 40 is the appointment of receiver. And collector can be appointed as a receiver is the rule 5 of this order, which is obviously very important. So yeah, option number C is the correct answer. 20 ka 21st question is, the Code of Civil Procedure Amendment Act 2002 came into force on 1st April 2002, 1st June 2002, 6th June 2002 or 1st July 2002. Okay, stop answering. ठीक है. So the correct answer is option number D, 1st July 2002. कुछ CPC में major amendments हैं. It is not like IPC. It is not something like company law कि जहाँ पे हर रोज amendment आई है. CPC में बहुत कम amendments आई हैं. So CPC में जो amendments आई हैं वो एक तो 1976 की आई गेस और एक 2002 की है. दिस इज 2002 अमेंडमेंट इज वेरी इंपॉर्टेंट. वो प्लेंट का डुप्लीकेट होना, ऑर्डर 26, सेक्शन 26, ऑर्डर 4, ये सब में अमेंडमेंट और ये 2002 में आई थी. सो द डेट ऑफ एनफोर्समेंट इज वेरी इंपॉर्टेंट. 1st July 2002 इज द डेट हियर, सो यू मस्ट रिमेंबर द डेट. ठीक है. लास्ट few questions are left, guys. Baka, please start answering the questions. 22nd question is, books of account are liable to attachment and sale in execution of a decree, are not liable to attachment and sale in execution of a decree, are no evidence in the eye of law, can be the sole evidence to decide a suit. बिहार के पेपर से मैंने ये क्वेश्चन उठाया है. बिहार आई गेस 2016 के पेपर से क्वेश्चन है. Stop answering. Okay, so the correct answer is option number B. Option number B is the correct answer. पहला point section 60 का है books of account. I've already told you section 60 में ये लिखा हुआ है things which cannot be attached and sold obviously. तो ये books of account is one of those things जहाँ जो नहीं आप बेच सकते, नहीं आप attach कर सकते in execution of a decree of a person. तो books of account cannot be sold and attached. Okay. ठीक है. So question number 23 is the Code of Civil Procedure exempts Minister of States from personal appearance in court, does not exempt any person from personal appearance in court, exempts advocates from personal appearance in courts, exempts municipal commissioners from personal appearance in courts. Come on. Okay, stop answering. Yeah. So the correct answer is A. Option number A is the correct answer. Exempts Minister of States from personal appearance in courts. सेक्शन 133 में ये लिखा हुआ है, 133 आई गेस क्लॉज 9 है या 10 है, वहां पे ये लिखा है कि मिनिस्टर ऑफ स्टेट्स आर एग्जेम्प्टेड फ्रॉम द पर्सनल अपीयरेंस इन कोर्ट. 133 section 133 of civil procedure code. So certain persons are exempted from the personal appearance. One of such persons are minister of states, member of legislative assemblies and all that. तो वो कुछ sections हैं last के 133 134. So those sections are also very important. Okay. So question number 24 is a plaintiff cannot unite several causes of action in the same suit. Can unite several causes of action in the same suit against the same defendant. Unite only some causes of action in a suit. Unite only the questions of law in a suit. Okay, stop answering. So the correct answer is option number B. Option number B is the correct answer. This power given to plaintiff is by the virtue of Order 2 Rule 4. Order 2 Rule 4 mein he can unite several causes of action and the grounds are mentioned there, but he can obviously do that. So option number B is the correct answer. ठीक है. Question number 25. Anu, shall I move on? Okay. Yeah.
Yes, yes.
Okay.
Yes,
Question
I'm
number
asking answers.
Okay. Question number 25 is the court can allow amendment of pleading at any stage of the proceedings. A party can amend its pleading at any stage, cannot allow amendment of pleadings, can allow amendment of written statement only. Guys, मैंने अभी आंसर दिया था इसका. Explain करते करते. Everyone should answer this question. किसी एक ने हमें धोखा दे दिया है और लेफ्ट कर दिया है. So we have 15 participants now, but ठीक है. Please answer the question. Okay. Stop answering. So the correct answer is option A. Option A is the correct answer. The plaintiff can allow the amendment, the court can allow the amendment of pleadings at any stage of the proceedings. Order 6 is the relevant order here and amendment of pleadings का rule है 14 और उसका वो rule है 18 and the time, yeah, rule है 17 and 18 and the time limit is 14 days. अगर time limit नहीं mention है तो then you can amend the pleadings till 14 days. Okay. So this is the correct answer. Question number 20.
I guess people might have doubt in the last question in option A and B. Mahima, so if you can clarify, why not option B?
A party can obviously amend the pleadings, but it is the court who will allow you to amend the pleading. So the court, ये
language. So the court, a party.
Yeah, that is the difference.
Yes,
So
yes.
इसलिए it is highly recommended to read the question twice. बहुत बार read करो then mark the question. अभी कोई देख के option B ही mark कर देता. Even I could have marked option B in that case. So yeah.
We have received answers B as well, no? Okay.
Okay. ठीक है. 26th question is then inherent powers of the court can be exercised for the ends of justice or to prevent abuse of the process of court, even when there is specific provision in the Code of Civil Procedure to help a party to defeat the end of justice. Guys, easiest question for today's session. Okay. Stop answering. So the correct answer is option number A. Option number A is the correct answer. Section 151 में ये mention है कि the High Court can exercise the inherent powers, their inherent powers for on these grounds. सिर्फ यही grounds है जिनके लिए वो exercise कर सकता है. तो option number D तो is no sense to defeat the end of justice, and so yeah, to help a party is also not the case here. So option number A is the correct answer. 26 का option number A is the correct. Okay. 4 questions are left. I would want every one of you to participate. Question number 27 is, no suit shall be instituted in case of government except by serving a notice is given under 50, 51, section 80 or section 81. Okay. Stop answering. So the correct answer is option number C. Option number C is the correct answer. C. ठीक है. Section 80 में ये requirement fulfill करने का mandatory provision है that in case of a suit against or against government, a notice should be served and the period of 3 months should be followed. So yeah, that is there. Okay. Question number 27. Question number 28. Let's move on to the question number 28 then. Where a suit abates or dismissed under Order 22 of CPC on the same cause of action, new suit may institute with the consent of parties. With prior permission of the court, fresh suit may be filed. No fresh suit shall be brought. If sufficient cause shown, then new suit may be filed. Few more seconds are left. Try to answer as much as possible, guys. Okay, stop answering. Yeah, so the correct answer is option number C. Option C is the correct answer. C. No fresh suit shall be brought. C. Okay. Order 22 रूल 9 का सब क्लॉज 1 है relevant provision, जहाँ पे ये है कि अगर अबेट हो जाता है या डिसमिस हो जाता है on the ground mentioned under that order, and that is death or insolvency, तो उन cases में no fresh suit shall be brought. A fresh suit is barred in that case. ठीक है. Okay. Order 22 is that. 29th question. Let's move on to towards the 29th question then. The provision for substituted service of summons on the defendants has been made under Order 5 Rule 19, Order 5 Rule 19 of CPC. Okay. Order 5 Rule 19A of CPC, Order 5 Rule 20 of CPC. Those who will mark option A and B will be given correct. अगर वो सही है तो do not mark option A and B, guys, कि मैंने बोल दिया ऐसा. Okay, stop answering. So the correct answer is option number D, not A and B. Option number D is the correct answer. इसलिए मैंने बोला था धोखा हो जाएगा अभी. Option number D is the correct answer. Substituted services are given under option number D and not A and B. So that is there. Substituted service order 5 का बहुत important provision है where the court allows someone else to serve the summons, and that is under order 5 rule 20. So remember the order, rule, and also the provision. Okay. Last question is, the period of retention in civil imprisonment as a consequence of disobedience or breach of any injunction shall not exceed 1 month, 3 months, 6 months, 1 year. This is the last question, guys. Okay. Stop answering. Yeah. So the correct answer is option number B. ठीक है, तो 3 months is the correct answer. Order 39 Rule 2A में ये लिखा हुआ है कि अगर disobedience होता है in case of injunction or any interlocutory orders, then the punishment would be 3 months, not exceeding 3 months. So yeah, that was it for today's session. I can see 2 more people have left us. कोई बात
Yes,
नहीं.
yes. Yes, Mahima. Yeah, this was amazing quiz, and the questions were also very great. So I'll just get back with our top three winners from both Zoom and YouTube session. So just take over the webinar, and we'll be back.
Okay. ठीक है, so I can see people on YouTube also. ठीक है, तो फिर as I have already told you guys that the workshop is going to be conducted on 14 December. If any one of you is interested, you can just write it in the chat box. Till then, I can if you guys have any doubts, you can ask, or if in case, okay, I can see one question from Sanjay Negi. It will be on YouTube. You can type LawSikho and then you will find the latest webinars there. 2 बजे जो webinar हुआ है वो वहीं पे मिल जाएगा. अगर नहीं मिलता है तो then it will be get uploaded shortly. Yeah. If anyone have any doubt regarding the questions, regarding the kind of questions or regarding anything else, you can just write it in the chat box, or anything you want to suggest for this streak we are doing for the live mocks. कोई improvement है, कोई suggestion है? कुछ नहीं है. Okay, then I think you should just give a feedback. Rate this webinar from 1 to 10, 1 being the lowest and 10 being the highest. Okay. How to remember the number of sections, orders, and rules, anonymous attendees. See, this is something very tricky and very depending upon it depends totally upon the person to person, how you can remember the sections and orders. One of the easiest hack for it is to, just a second, my battery is low. Yeah, one of the hack to it is write on the pages and stick on your walls. अपनी दीवारों पे चिपकाना start कर दो, भर दो दीवारें, and then you will obviously remember the sections. कुछ sections नहीं याद होते हैं, कुछ orders कभी याद नहीं हो जाते हैं, तो for them also try to write them, try to memorize them. और CPC के लिए तो order की headings, all the orders 51 orders की headings you should know. Headings तो आनी ही चाहिए. So yeah.
Right. Thanks, Mahima, for sharing insights. And I hope people have whatever queries they had. So I believe they had asked. So let me just quickly announce our today's winners for the session. And the session was great. And those who missed the session, I would definitely suggest कि आज के questions देखें. CPC पे काफी important questions हो सकते हैं for your examination purpose. So also please share a feedback with us. So now I'm going to announce our today's winners from Zoom से भी हैं और YouTube से भी हैं. So I've taken 3 positions today, and जो third position पे है, we have with us Mr. Jagannath. So congratulations, Jagannath. जो second position पे है, that attendee is from YouTube session. So his name is Manish Kholia. So he has also secured a good rank. Also he joined late, so yeah. And जो first position पे है, he is Mr. Yashveer Singh with the highest mark. So congratulations, Yashveer, Manish, and Jagannath. And of course, I am appreciating the fact that many of the participants participated. तो अच्छा था session, and please let us know in the comment box ki how you find the session, the questions, and your wishes, like कि हम next mock किस subjects पे करें. So if you have any suggestions for the session, you can type in a chat box, and rest you can provide your feedback to us on the scale of 1 to 10.
Guys, YouTube पे भी जो webinars देख रहे हैं, they can also share their feedbacks. And
Right.
Zoom पे, I guess, some people have already given their feedbacks. There are 13 people, guys. Feedback तो दे दिया करो यार, please.
It's help us to improve the quality content.
Exactly.
Right. Okay, so I guess we have taken all the questions from today's session, and also participants, I have shared the link with you all for a judiciary workshop along with the chat WhatsApp group. तो आप join कर सकते हैं, and जो भी interested है, and अगर किसी को payment link and anything if they required, so they can write in a chat box and contact us accordingly.
Great. Nishi Kumari is writing. Okay. So,
Right. Okay, so Mahima, thank you for conducting today's quiz, and thank you participants for joining today's webinar. We'll be conducting, live practice frequently. So keep quizzing and stay connected with 𝗖𝗍. And thanks Mahima, thanks participants again. And then, now I'll sign off, webinar executive 𝗍𝗶𝗃𝗏. Thank you everyone. Yes,
bye.
yes, Rohan, we have taken your suggestion. Thank you for that. Yes, we have taken suggestion from YouTube as well. Advocate Devanjana. Yes, next mock on evidence. Yes, yes, definitely we'll try to cover all your suggestions in our live practice. Till then, stay safe and stay at home. And now I'll sign off. Thank you, everyone.
Bye, guys. Thank you, Anu. Thank you.